Now let us look into what kind of discretion or administrative discretion on the part of these authorities. In most administrative actions, the administrative authorities has the power either to act or not to act in one way or the other. The power to act or not to act in one way or other is called discretionary power of the administrative authorities. Discretion is the power to decide or act according to one's judgment. The exercise of discretion should not be arbitrary, vague, fanciful, but it should be legal and regular. In India, while discharging their functions, administrative authorities exercise discretion. Government has to measure it upon the standard of constitutional provisions of equality, freedom and justice. Government needs discretion for the proper conduct of its functions. However, it should exercise its power well within the constitutional limits. They should not go beyond the limits prescribed under the Constitution. If you have discretion on the part of administrative authorities, it is broadly classified into two categories. One is absolute discretion, other is arbitrary state action. Let us look into each category separately. First, let us look into what is meant by absolute discretion. Law confers absolute as well as uncontrolled discretion on any authority which violates equal protection of laws as per Article 14. Article 14 deals with equality before law and equal protection of laws. Any absolute discretion falls or it comes within the purview of Article 14 and it can be controlled by judicial authority. Unfettered power is invalid in the absence of guidelines or principles or norms which are essential for exercise of power. Let us look into few case laws on this aspect about absolute discretion. One of the most landmark case decided by the Supreme Court, Air India was case Nargis Mirza in the year 1981. In this case, the normal age for retirement of an air hostess was fixed at 35 years. Based on a regulation of the corporation, the managing director was authorized to increase the retirement age up to 45 years. The managing director was empowered to use discretion based upon his personal opinion. In this case, the court held that it was a clear case of official arbitrariness and struck down the scope of regulation where the MD could extend the services of an authority, an air hostess. The next landmark case is Maneka Gandhi vs. Union of India 1975 landmark judgment. In this case, the power conferred on the Passport Authority as per section 10(3) clause C of the Passport Act to import any passport in the interest of general public. It has been held to be not unguided or unconstitutional, uncontrolled. The ground is not vague and indefinite. These words have well defined meaning as they have been taken from Article 19 clause 5. So in this case, there are several safeguards were laid down before impounding the passport, like recording the statement for impounding the passport, supplying a copy thereof to the affected person, and appeal from this order to higher authority and hearing of the affected person is mandatory. Based on these guidelines, if the authority impound any passport, it does not violate Article 14, 21 or 19 of Indian Constitution. So next, let us look into arbitrary state action. Any discrimination in state action falls within the purview of Article 14, and the court can strike down such action as illegal or unconstitutional or ultra vires. Every action of the state must be enforced by reason and guided by public interest. In number of cases, government action has been quashed on the ground of it being arbitrary or discriminatory. Article 14 strikes not only at discrimination but also at arbitrariness in general. For example, spot admission on the last day for vacant seats without notice in the state-owned institution for higher professional education institutions was held arbitrary as it denied equality of opportunity and the test of merit. There is a need to control such arbitrary action on behalf of the state or by administrative authorities. Subordinate authority who fail to perform his duties, functions or his act was arbitrary, or it can be called as discretionary in decision making, then higher authority can take action against him. Basing on the complaint in relation to arbitrary action or misconduct on the part of the subordinate authority, the higher authority can remove, dismiss or reduce the rank of the subordinate authority. While doing so, the higher authority should follow the principles of natural justice. So now let us look into what are the principles of natural justice, how these natural justice principles are incorporated. To control arbitrary action on the part of administrative authority, the affected person should be given the right of being heard before such authority passes any order against him. In this situation, the court insisted there is a need to follow principles of natural justice. The word natural justice derived from a Roman word jus naturale, which means principles of natural law, justice, equity and good conscience. The use of the term natural justice in the judicial context is very important and frequent. Although there is an adjective natural qualifying the noun justice, the concept has nothing to do with the laws of nature, which rather runs counter to it. The principles are accepted as early as the days of Adam and of Kautilya in his Arthashastra. The principles did not originate from any divine power, but are outcome of the necessity of judicial thinking as well as necessity to evolve the norms of fair play. These are the principles which every disciplinary authority should follow while taking any decision which may adversely affect the rights of the individuals. It is to be seen that rules of natural justice are not codified anywhere. They are procedural norms in nature, and their aim is to ensure delivery of justice to the parties. The principles of natural justice have their roots in two Latin maxims. One is audi alteram partem, that means to hear the other party. Before giving any decision, they need to hear the other party. The second Latin maxim is nemo judex in suo causa, means no one should be judged in his own case. Beside this, there is one more category which came into existence. Before giving any decision, and the decision should be based upon evidence and records and findings. The principles of natural justice over the decade evolved all over the world, which has its genesis in common law of England. The common law was a set of unwritten law which existed in the form of usages and conventions and adopted subsequently as laws. Rules of natural justice serve as watch against any deliberate discrimination against rights of individuals. These rules are intended to prevent such authority from doing injustice. The principles of natural justice are easy to proclaim, but their precise extent is far less easy to define. The rule against bias is one thing, the right to be heard is another most important principles of natural justice. There are two or twin pillars supporting the concept. They have been put into two words: impartiality and fairness. Before the removal or dismissal or reduction in the rank of any employee, the employer can follow any one of the different methods. At the time of applying these methods, the appropriate authority should follow the principles of natural justice. The first method is domestic inquiry and second is departmental inquiry. In departmental inquiry, they have to look into preliminary investigation. So after the investigation, they can take action, that is we calculate it as departmental action, that is they can suspend or they can file a criminal case against the person. The second is disciplinary proceedings.